Environmental protection under the law of tort. Under that, there are three main categories of the tort. First is the nuisance, second is the negligence, and third is the strict liability. Rule of strict liability and absolute liability. Strict liability: the person who keeps intrinsically dangerous things on his land is liable if such things escape and cause loss or damage to others. Means those things which are dangerous in nature, and if such things escape or cause loss or damage to the others, then that person will be liable who is keeping such dangerous things. A person is legally responsible for the consequences flowing from an activity even in the absence of a fault, negligence, criminal intent on the part of the defendant. Means as these things are dangerous in nature, and if these things escape from the premise of that person and it causes any loss to the other person, then such a person will be held responsible because he has kept that such things in his premise, and there is an absence of a fault, negligence, criminal intent on the part of the defendant, then also that defendant will be held liable. This is the strict liability. Absolute liability: when any person involves an ultra hazardous activities such as keeping wild animals, using explosives, or making defective products or any poisonous substances, then he or she is held liable if any other person is injured because of that activity. Means here the fault, negligence, criminal intent is not necessary. If such dangerous things, hazardous things escape from the premise and it causes any danger or any loss to the other person, then that person will be held liable. Essentials of the strict liability is that things must be in a dangerous nature, escape is necessary, and second is non-natural use of the land. Now for this strict liability there are exceptions. That is the act of the God, consent of the plaintiff, act of a third party, statutory authority, plaintiff's own default. For strict liability there are certain exceptions, but for the absolute liability there are no exceptions. Exceptions: first is the act of a God. Act of the God means which measure? Things in which there is no interference of human beings or that are unnatural in nature, then such things can be said as an act of a God. Second is consent of the plaintiff, means in any act the plaintiff has given consent and that time the loss has happened, then the plaintiff cannot blame to the defendant because that act has, for that act the consent of this plaintiff has been taken. When this act is happened because of the third party, then here the defendant cannot be held liable because that act was happened because of the third party. Under the statutory authority, if the act has been done and if any loss has happened to the plaintiff, then here the defendant cannot be held liable. And fourth is the plaintiff's own default, means because of the plaintiff's own default the loss has happened, then here the plaintiff cannot blame to the defendant. These are the exceptions to the strict liability. Next is the absolute liability. So it is the application of a strict liability but without the exceptions. In the absolute liability there is no defense. It is a liability imposed regardless of negligence, fault, and intent. Means here in the absolute liability, when the loss is happened to the another person, that time the negligence, fault, and intent is not viewed. It applies to the non-natural and the natural uses of a land. In this, an enterprise can be made liable even without an escape. In strict liability there are exceptions. In absolute liability there are no exceptions. So here we have seen the provisions of law of tort which belongs to the environmental protection. In this law of tort there are three main categories: nuisance, negligence, and strict liability.